behalf of Colley and Shuker and others.
Yes. Managed to break my mask. Forgive me a minute. My lords, I appear with Mr. Pobjoy for the appellant.
Yes. No.
And you know, Mr. Moser and Mr. Mead appear for Mr. Colley, the respondent. In terms of housekeeping, I hope you've had the two very short supplementary notes addressing the recent authority.
Yes, thank you.
I've stuck mine behind the skeletons in the call bundle. There is a fourth defendant of relevance, the Secretary of State for Transport. They've chosen not to appear in this appeal or the preliminary issue trial below, to which it relates, even though they are a party, and even though, as you'll hear me explain, we consider that ultimately the nature of this case is somewhat of a cutthroat defence. Because I would suggest that the real issue in this case is not whether the claimant's claim should be paid, but rather which of the MIB or the Secretary of State should pay it. What is striking, as we shall see, is that in the case of Delaney, the High Court in 2014, well before the accident here, and the Court of Appeal in March 2015, again just before the accident, concluded that the state of our law then, which allowed insurance policies to be avoided, was in breach of the motor insurance directives because it left the claimant in that case without a remedy, and that breach was sufficiently serious given the clear state of the case law on Articles 3 and 13 as they are now, to give rise to liability on the Secretary of State's part. So why is the MIB in focus here? Because in the interim, it has been identified to be a public authority, whereas previously it was thought not to be, such that it is said that the claim of the kind articulated in Delaney can be made directly on the guarantee fund. So we have the Secretary of State effectively lurking in the shadows, seemingly content to let the MIB pick up the bill for his sustained failure until 2019 to correct the terms of Section 152 of the Road Traffic Act. And it's led, we would submit, to an unsatisfactory state of affairs, whereby the respondent seeks, what is in our view, a strained and unprincipled interpretation of the relevant EU legislation so as to ensure compensation, in circumstances where there is a clear, straightforward and answerable route to compensation available, namely a factor tank claim. This is not a case where there is any gap in protection. It's a case where it's the Secretary of State that should be paying, not the MIB. Now, given the punchiness with which I just put that point, we've needed to say written to the Secretary.
Can we go home now?
Sorry?
Can we go home now?
Absolutely. We've written to the Secretary of State to remind him of this litigation to which he's a party and to give notice of this hearing and to point out we're going to be forcefully making the points I've just articulated, and he's chosen not to attend. No doubt there's someone on the live stream, pen in hand, taking a careful note, but that's where we're at.
You say, Mr. Delamere, that it's a clear route to compensation.
Yes.
From the Secretary of State. As I understand it, the Secretary of State defends the claim on the basis that although there may in principle be liability, there isn't in practice here.
Well, I'll come to that in due course. We'll have a look briefly at the defence that's been put forward, paragraphs 10A to G, it's in the supplementary bundle. It's quite instructive to compare its contents with the contents of Mr. Justice J's judgment in Delaney, because effectively the argument is made, well, Fidelidade came as a terrible surprise to us, whereas in truth, the root problem in this case is the Candolin case and everything that preceded it back in 2005. But I'll make that point momentarily. The factual background, you'll have seen from the papers, is relatively straightforward. This arises out of a tragic motor traffic accident on the 27th of March 2015, in which the claimant, now the respondent, was catastrophically injured. The relevant facts are set out, as you've seen in the supplementary bundle, tab 1. But the key points in my submission are as follows. Mr. Colley was a passenger in a car negligently driven by his friend, D1, Mr. Shuker, who did not hold a full licence, only a provisional licence. And as such, he wasn't able to drive unless supervised by another driver over the age of 21 with a driving licence. D1 was the registered keeper of the car, but it was insured by his father, with only the father and his partner being insured to drive it. So at the time in question, the vehicle was indeed insured for the purposes of the directive. However, the insurer, D2, UK Insurance Limited, was not told that D1 was the registered keeper or that D1 would be using it. And that meant the policy was from the get-go liable to be avoided on grounds of misrepresentation. Equally, at all material times, Mr. Colley knew that D1 did not have a valid licence and that he was not a user insured to drive the car. And that agreed fact at paragraph 6 of the agreed fact is also recorded at paragraph 7 of the judgment. Now,
I'm so sorry to interrupt you, Mr. Delamo. I do apologise for doing so, but something you said has reminded me. I'm sure I saw a message at some stage to say that Mr. Colley would wish to attend and that arrangements would need to be made for access. I'm just troubled. I can't see him, and so I wonder if there's been any problem.
My lord, yes. There has been a problem to do with a family crisis.
Oh, I see. Nothing to do with access.
Nothing to do with access, my lords. Happily, it's being live streamed, and Mr. Colley will be watching this at home.
Right. Good. Thank you for setting my mind at ease.
Thank you for your concern.
Yes, I apologise again, Mr.
So we're in a circumstance where, but for the avoidability of the policy in the particular circumstances of this case, D2 UK Insurance Limited would have been liable to pay out on the claimant's injuries, even though the claimant was knowingly being driven in a car by a driver he knew to be an uninsured driver. The genesis of this litigation lies in the fact that D2 was, even after the accident, able to avoid the policy under the old form of Section 152 of the RTA on grounds of misrep. It therefore was a provision, Section 152, that enabled an insurer to avoid paying out in relation to an accident that occurred before avoidance, thereby leaving the victim with no insurer to pursue. And just for your note at this stage, and I'm going to go through the provisions in a bit more detail, you can find the old form of Section 152 in the Authorities Bundle, tab 2 at page 9. Now, as we're going to see, that old form at the time of breach, at the time of the accident, was a plain breach of what is now Article 13 of the Directive, which, at least as clearly construed by the CJEU since at least 2005, does not permit any such avoidance other than in one very narrow circumstance. That's where you knowingly get into a stolen car. I'm going to call that the Joyrider Exception. That's effectively the situation it's designed to cover. The general policy of the directive, as consistently interpreted by the CJEU since the Real Spinalz's case, is, I'd suggest, very clear. Any statutory or contractual provision or exclusion which would enable a motor insurer to avoid satisfying an established liability to the victim of an accident is prohibited. And member states, under Article 3, as now is, have an obligation to ensure that their national legislation fully implements the directive in that respect. So avoidance or exclusion by an insurer vis-à-vis the victim is forbidden except under the Joyrider Exception. So what happens is that instead the directive requires such questions of nullity to be treated only as matters as between the insured and the insurer, but incapable of giving rise to defences to claims made by the victim. So long as the victim's paid out, there's nothing in the directive that will then prevent recourse by the insurer against the insured, for instance, for misrepresentation, or indeed against the driver for causing the accident, so long as the claim makes financial sense, so long as they've got money to pursue. And as we'll see, the case of Giuliano, on which my learned friend relies, is one such case in substance. Such incompatibility between Section 152 and what is now Article 13 of the Directive has been certainly indisputable since it was admitted by the Secretary of State in the road peace litigation in 2017, such admission apparently being made on the strength of the Dade. But I would suggest it's been clear for a long time before that, back to at least 2005. The problem here is that the defect wasn't cured until Section 152 was amended in November 2019 by secondary legislation made under Section 2.2 of the European Communities Act to cure the admitted incompatibility. And the problem is that here in the interim, on the 27th of June 2016, some 15 months after the accident, D2 obtained an order under Section 152 declaring the policy avoided on grounds of misrepresentation. Those facts make this case directly analogous to the Irish case of Smith and Mead, a case that went to the CJEU, to which I will come. And you'll be unsurprised to hear, as is often the case, that many aspects of the relevant Irish legislation and arrangements are very similar indeed to those in the UK. The last piece of the factual jigsaw is this. In March 2019, fortified it would seem by the then recent road peace decision, but before this court's decision in Lewis and Tyndale, the claimant first tried to contest the legal effect of such Section 152 declaration by an inventive but doomed Marleasing argument to argue in effect that the Section 152 declaration should be set aside under the court's inherent jurisdiction, even if the legislative terms of Section 152 had to be left intact. And that case was argued before and rejected by Mrs. Justice O'Farrell in her judgment of the 28th of March 2019. You'll find that in Authorities Bundle 2 at tab 43. It was rejected on the basis that although the incompatibility with Article 13 was clear, purposive interpretation of Section 152 was impossible because it would have been contra legem. And D2, the insurer, was a private body and as such outside any scope of the direct effect doctrine. And in rejecting the Marleasing argument, Mrs. Justice O'Farrell pointed to the near identicality of Smith and Mead as conclusive proof that purposive interpretation was impossible and that the only remedy was a fact-attained damages claim. And you can see that at paragraph 37 and again at paragraph 69. And it was that reason that we think led to the joinder of the fourth defendant. You can see from that judgment there was an application to join the fourth defendant to the proceedings for the fact-attained damages claim, and that application was permitted in the same judgment at paragraph 69. So what happened next was Lewis and Tyndale came along. The MIB was identified as being an emanation of the state, and instead of pursuing the fact-attained claim identified by Mrs. Justice O'Farrell, we have the claim against the MIB on the predicate, no doubt, that we're a softer target because we don't have to, or they don't have to establish a sufficiently serious breach test in relation to us. It's a simple argument, according to my learned friend.
Do you accept, is it common ground for the purposes of this hearing, that A, that you're an emanation of the state, I know the answer to that, B, that Article 10 is directly enforceable against you?
Indeed, you're just anticipating the exact concessions I was going to make, my lord.
Okay.
Now, let me be very clear about what we do accept. We do accept that the MIB, at least for the purposes of meeting claims in relation to untraced drivers and wholly uninsured drivers, that's drivers for whom there never has been a relevant policy of insurance in force at the time of the accident, is the body entrusted and required to meet the guarantee obligations under Article 10.
Just say again, because MIB, for the purposes of meeting untraced and wholly uninsured drivers,
yes.
by which you mean never been a policy.
No policy in force at the time of the accident.
No policy in force. So not never been a policy, but no policy in force at the time.
That's the critical factor that distinguishes this case. There was a policy in force at the time of the accident.
Yeah. Okay. For those purposes, the MIB is what?
is an emanation of the state.
Thank you.
And that's because it has special powers. The special powers are in substance the compulsion in the Road Traffic Act for anyone writing compulsory motor insurance to be an authorised insurer, as defined by section 95(2), and an authorised insurer and a member of the MIB. And through that structure, effectively, what the Act says is insurance is compulsory, the insurer has to be a member of the MIB, and in that way the MIB has the power, through its articles of association, to raise levies to pay for the funds necessary to meet the Article 10 obligation. It's effectively what a community lawyer would call a parafiscal tax. Those are the special powers, and we accept that those make the MIB an emanation of the state, and such is conclusively established by this court's judgment, at least in this court, by in Lewis and Tyndale, Authorities Bundle tab 44. It's important to point out that Lewis involved an accident involving a wholly uninsured car. Mr. Tyndale's 4x4 was some kind of farm car that had no policy of insurance in place at the relevant time. The case of Lewis is complicated by the fact that there was also raging in parallel, and you need to appreciate this when reading the case law, the whole Vanuk controversy, because the CJEU had decided that the obligations under the directive didn't just extend to road use, but also to use on private land. And the accident in Lewis and Tyndale occurred on private land. In any event, 2 months after Mrs. Justice O'Farrell's decision in this case, on the first preliminary issue, along comes Lewis and Tyndale and decides that the MIB is a public authority. But our point really comes down to this. The claim in direct effect against the MIB as an emanation of the state is only good if it's within the substantive bounds of the duty to guarantee compensation contained in Article 10(1). And that's the question that sits at the heart of this appeal. The question is ultimately whether the MIB, as the Article 10 guarantor, is responsible for guaranteeing against any loss that might be caused by the Member State's breach of the Motor Insurance Directive, any breach that leads to a less than perfect transposition of the Article 3 obligation. And the answer to that question depends upon where you locate the remedy for the relevant breach of EU law and the consequential obligations in relation to such breach. We're all agreed, I think, that Article 13 prohibits avoidance of policies of insurance against the victim after the accident. And we're all agreed that Article 13 has been breached in this case by the fact that D2 was allowed to avoid liability. That much is clear common ground between us. The question is rather whether, as the claimant says, the purpose of the guarantee fund is to guarantee not just against losses caused by untrained drivers or losses caused by drivers who were not insured at the time of the accident, uninsured drivers, but also to guarantee against the state's own breaches for failures to properly implement the directive by permitting the avoidance after the accident of a policy of insurance in place at the time. Now we say there is simply no need to distort the proper duties and functioning of the guarantee body such that it effectively has to just underwrite not only untraced or wholly uninsured drivers, but also the state. We say for those losses it's the state that's answerable under a factor-taking claim. And following Delaney and the reasoning it contains, the claimant would plainly win that case. Now, the position of the claimant, with which the court agreed, and really the focus of this appeal, is that properly construed, Article 10 of the Codified Directive has a third category of case, in that it requires a guarantee fund to remedy any failure to implement obligations under Articles 3 and 13 of the Directive. That's clear from paragraphs 12 to 13 of the judgment, from the whole tenor of the discussion section after the very careful review of all of the authority. That's really the key issue.
That's paragraph 12 and 13 of Mr. Justice J.
Mr. Justice Freedman's judgment.
So, okay.
So in other words, the learned judge below has concluded that even where the car was insured at the time of the accident, the MIB is liable to compensate if, in breach of Article 13, the insurer is allowed to avoid the policy of insurance.
But just so I know where you're going, at which stage in your submissions are you going to deal with the impact that an avoidance is ab initio?
I'm going to deal with that when we go through the cases that deal with avoidance and show that that type of reasoning is simply impermissible, and plainly is impermissible and has long been impermissible. And exactly that issue arose in Fidelidade, where the Portuguese argument was effectively it's a nullity, it's void ab initio because of misrep, and the CJEU said no.
But that's your, as it were, your home banker case, isn't it, on avoidance ab initio?
Yes. Yes.
And that's on the basis that in the judgments it's described as being a nullity, from which we infer that it's a nullity from the start.
Yes.
Which is on one of the lines of Portuguese reasoning.
Yes, and it frankly must follow from the principle that EU law leads to principles of uniform interpretation. Once you understand the protective rationale of Articles 3 and 13, whether or not they bite can't depend upon the vagaries or adventitious nature of national law and how it treats actionable misrepresentation, whether it's voidable ab initio, void ab initio, voidable, etc. That's a vagary of the national law that EU law is generally pretty disinterested in. And you get that very clearly from the judgments in my submission. So the claimant's case, upheld by the judge, is that it's within scope as a third category if the relevant insurer has been allowed in breach of the directive to avoid its policy. And that's said to be supported by the language of Article 10.1, and in particular the term, and this really is the key term, there's no escaping that, a vehicle for which the insurance obligation provided by Article 3 has not been satisfied. The claimant and the judge below read those words widely to embrace the third category of claim. Since the mandatory insurance required by Article 3 had been avoided, it was said that there was a breach of the requirements of Article 3, and so it was within scope of Article 10. And in so reasoning, both they and the judge very heavily relied upon the case of Delaney, to which I'll come, both at first instance in this court. Now, our position is very simple. It's that the phrase, a vehicle for which the insurance obligation provided by Article 3 has not been satisfied, is no more than synonymous with a wholly uninsured vehicle. That's a vehicle that was not covered by a policy of insurance in any way at the time of the accident. And that term does not, we say, embrace a vehicle which was insured, but whose insurance was subsequently avoided after the accident in breach of Article 13. And if we're right on that, the scope of Article 10 is more limited, and it follows, therefore, that the directly effective claim against the MIB fails, and that the relevant remedy is the factor 10 claim. Now, you'll have seen from our skeleton, we support our argument on that key issue by reference to three things. The first is the text of Article 10.1 itself, read with the entirety of the codified directive, especially, but not limited to, Article 10.2 and Recital 14. So we say you can get there simply by reading the directive as a whole, particularly the recitals, and particularly the language of the directive where it uses the term uninsured vehicle and the synonym, therefore. The second basis we put our case on is the travaux préparatoires to the second directive, which introduced what became Articles 10 and 13. And those travaux show very clearly that the Commission attempted to insert an express third category of case where avoidance was permitted, for which the guarantee fund would respond. And they also show the council's very clear rejection of any such third category of case. And then the third thing we rely upon is 4 CJEU cases, starting with Shuker, then the adoption of the reasoning in Shuker, an insolvency case by Fidelidade case, which was a case explicitly about exclusion of liability or avoidance. Then Smith and Mead, which, as I've described, is an exact analogue for this case, where the court located the relevant remedy as lying in a franklage claim. And then lastly, the reasoned order of Seguros, which landed very recently. Those cases...
Does Seguros add anything additional apart from being a restatement of whatever it is, paragraph 35 of Shuker?
That is its main gravamen, absolutely. So
you just say they're still saying it.
Exactly. If it's not a bit catty, that's quite important with the CJEU, that they've stuck to their guns, notwithstanding the fact that there's been pushback from the member states. They've stuck to their guns, and they've actually stuck to their guns to the extent that they've dismissed the case by reasoned order. We are...
So we have a slightly odd opposition, which I have to say I've not got my head around properly yet at all, which is that it's accepted that the Section 152 route was a breach.
Yep.
It's accepted that the MIB is an emanation of the state which breached that.
Not that the MIB breached that. No, the breach of Section 152
was implemented by another emanation of the state, namely the Secretary of State.
And by the courts, actually, by giving effect to a declaration. But that's what they were bound to do, for the reasons identified by this.
We can shift the blame around, but it's not the MIB.
Correct.
But the net result of that is that the state of which you're an emanation has denied Mr. Colley the remedy that he ought to have had from his insurer.
Correct.
And it's then that I get into some difficulty as to how one formulates the next part of the sentence, apart from saying not me, Gov.
Well, it's definitely not me, Gov, but the relevant formulation is that the correct remedy in those circumstances lies against the party responsible for the breach, which is the Secretary of State, not the emanation of the state, because the function of the Article 10 body is limited to providing guarantee compensation only in the two categories of case: untraced drivers and drivers who never had at the time of the accident an in-force policy of insurance. And one of the ways you can illustrate that is that actually the directives contemplate 3 different guarantee bodies. You're made a guarantee body for a different function under the directive. There's actually one guarantee body for exempt categories of driver. There's another guarantee body for the Article 10 function. And then there's a third potential guarantee body for the cross-border function under Article 24 and following. That happens to be the MIB, but different member states, there are different guarantee bodies for each of those functions.
At the moment, I think that's a smoke and mirrors argument, but I'm not sure.
Well, with respect, it's not, my lord, because it's important to identify the function for which you are the relevant guarantee body, not least because that links to your special powers. And here, the special powers are effectively levy-making powers to raise funds to cover the common risks of there being uninsured drivers or untraced drivers. And that's how the MIB operates. And the effect of making it the guarantor of the UK's obligations as a whole is to fundamentally distort that basis and that essence of their special powers. That's why it's important. It's the wrong party paying, ultimately, for this litigation. It really comes down to this. The MIB has never been entrusted with the task of, in effect, guaranteeing all defective implementation of the codified directives obligations. whether contained in Article 3 or 13 or elsewhere. And as we go through the directive, you'll see there's any number of ways the directive can be breached.
Is it your submission that the decision in Lewis would have been different if there had been a policy in relation to the 4x4, but it hadn't covered use on private land?
That's a good question.
Good.
In those circumstances, there would have been a policy of insurance. It would have raised the same issues of potential avoidability or exclusion, and it would fall within the analysis that I'm advocating. Yes, I accept that.
Well, assume that there's no question of avoidance, of avoiding the policy. So in Lewis, you had a policy, but this is just assumed. You have a policy which covers for use on land, on public land, but not on private land. In your submission, is that within or out with the proper scope of the article, the obligation, the insuring obligation?
Well, in those circumstances, as we'll see, following the Uk line of case law, it's clear that the Article 3 obligation does extend to the use of the vehicle on private land. It's also clear from the cases cited by my learned friend, Juliana, etc., that the references to the insured obligation are coextensive with that obligation. In other words, the matching duty of the MIB, or the National Guarantee Body, is to provide a guarantee in circumstances where somebody is driving on private land without a policy of insurance. In circumstances where there is a policy of insurance, but in breach of Article 3 or 13 of the directive, you're permitted either to impose an exclusion, and the RTA generally regulates exclusions, or you're permitted to avoid the policy. Let's give a classic example where avoidance might be permitted now. It might be permitted now in circumstances where you had consumed alcohol before driving on private land. That might be a circumstance where it would be permissible because you wouldn't be in the RTA context. In each of those scenarios, we would say that there is an insurance policy, and the vice in those circumstances lies in the legislation permitting the insurance policy to provide only part of the cover required by the directive. I hope that's a clear, somewhat long answer to my Lord's question.
About just one thing, is the end result of that answer that the MIB would or would not be liable to the victim?
The end result of that answer is that if you accept my analysis in this case, we would not be liable in those circumstances because the relevant breach would lie in the fact that the policy of insurance that was in place was permitted to be limited or avoided or whatever scenario.
By the other emanation?
Yes. The facts of Lewis, that didn't arise because
there was no policy.
There was no policy.
There never had been a policy.
Never had been a policy.
Well, forgive me for interrupting. Just to be clear, what had happened in Lewis was that Mr. Tyndale had his 4x4 insured with a company called Tradewise. He just omitted to renew it. So at the time that he was chasing my client across his field with his 4x4, it was, as it happens, uninsured.
I'm very grateful to my learned friend for the clarification. It's neither here nor there as to why it was uninsured. It was uninsured.
There was not, on any view, a policy
Exactly. There
of
was
any
not.
sort.
There was not extant at the time of the accident any policy. That's the critical fact.
On your interpretation.
On my
of the case,
interpretation.
which I'm going to probably call Fidelio because I just can't get my head around it.
Fidelidade.
Yeah, thank you very much. Fenice.
My best cod Portuguese accent.
Yeah,
I'm going to call the Portuguese equivalent to, which crops up time and time again in the case law, I'm just going to call it MIBP, or MIB Portugal, because that's better than wrestling with the terms. You'll see it's almost as much of a repeat player in the cases as my learned friend Mr. Moser, who's been in pretty much all of these cases. So we say those four cases reinforce the analysis, and that is effectively the key battleground for ground one of the case. And as you've seen from my supplementary note, we no longer pursue our case in relation to ground two. Instead, we point to the very construction of Article 10.2 my learned friend relies upon as actual reinforcement of our case as to what is and must be meant by the term uninsured driver or uninsured vehicle. Because my learned friend, in response to ground two, said, no, uninsured vehicle must mean a vehicle for which there is no policy of insurance. And yet, that's the synonym that's used in the recitals for the lengthy phrase that appears in Article 10.1. And he can't, with respect, have it both ways. And we say that the logic of his position, when you look at the scheme of the directive as a whole, is that Article 10.1 has no wider compass than Article 10.2 when it's talking about uninsured vehicles. So let me get in with that rather lengthy intro, but it is quite a fiddly case on the law. Let me explain to you how I propose to proceed. The first thing I'm going to do is I'm going to open the directive quite lengthily and take you through the recitals and the key provisions. Then I'm going to show you, as my second topic, the travaux préparatoires and the evolving recitals and the attempts of the Commission to create a third category of case, which are rebuffed by the Council. Then, thirdly, I'm going to show you the domestic implementing measures of the RTA, etc. Fourthly, I'm going to relatively briefly show you the Article 13 case law, particularly Ruiz Benaldez and Candolin, and the summary of that case law in Road Piece. Fifthly, I'm going to take you through the four key cases that bear upon the scope of the Article 10.1 guarantee. So that's Sonka, Fidelidade, Smith and Mead, and Liberty. And I'm going to identify what we draw from. Sixthly, I'm going to address the two cases on which my learned friend relies so heavily, the two EU cases, which is Juliana and Ostrowski. And then seventhly and lastly, I'm going to address Delaney and Lewis and Tyndale, on which my learned friend relies so heavily. So, the directive, topic one. You'll find the directive in the first bundle of authorities at tab 12. Recital 1 gives you a flavour of everything that is codified by this directive, including the 5 preceding directives, the most important of which for our purposes is the second Council Directive 84/5, which is the directive which introduces by its Article 1.4 the Guarantee Fund, and also introduces what then becomes Article 13 of the Codified Directive. So you see that this is a codified directive. Recital 3 then recites the prime obligation of member states. It's member states that must take all appropriate measures to ensure that civil liability in the respective use of vehicles normally based in its territory is covered by insurance, the extent of liability, etc. Are to be determined on the basis of those measures.
And those measures are the appropriate measures in line 1, are they?
Yes.
I don't understand that as a sentence, but I mean, I've seen it many times. It makes no sense to me whatsoever.
There's a few phrases that crop up from time to time that don't make particular sense.
Yeah, unfortunately, we've got to rule on them.
Yes.
So what does it mean? The extent of the liability covered and the terms and conditions are to be determined on the basis of those measures, meaning all appropriate measures.
It means that on the strength of the national provisions giving effect to the duty to have in place a policy of insurance, the member states can go on to explain the nature and the extent of the cover required and make choices of the kind required under the directive as to whether or not you're going to impose a cap or not, or what rules of contributory negligence you're going to operate, or matters of that kind. It's the substantive choices about how you provide for liability.
Provided they take all appropriate measures.
Correct. So provided, and what that comes to mean is provided that you comply with the restrictions that are read into Article 3 about exclusions or avoidance of liability. Recital 4 this is the first pointer to one of the other guarantee institutions. And then over the page, recitals 6 to 8 are the beginnings or the evidence of what is a move in this directive to a pan-European scheme of insurance.
I'm sorry, Mr. Youngman, what has recital 4 got to do with anything?
I think I probably misnoted it. I think it's recital 10.
Right. Thank you.
Yeah, quite right. Nothing to do with the price of fish. My apologies. Recitals 6 to 8 are the pan-European model, which you'll see is then reflected in an obligation in Article 3 to insure for the entirety of the EU and the relevant mechanisms that are then contained for cross-border accidents. And then Recital 10, which is what I thought Recital 4 was, each member should be able to act in derogation from the general obligation to take out compulsory insurance in respect of vehicles belonging to certain natural or legal persons, public or private. And then this effectively permits you to exclude from the directive's regime by reference to function being undertaken by the driver. It's a user-based exemption. And it embraces things like military use or local authority use or use as an ambulance.
It's basically, aren't there two categories? One is people who basically have the government standing behind them, so they're not
So the government self-insures.
They're not an insolvency risk.
That's right.
And the other is, which is implemented, I think, is people who take out a security bond of a certain level. Does that still exist?
they're the author of the law of motor insurance has got me cold. I'm not sure that about that third category, but certainly the first category.
I might possibly be a bit rusty as to that.
Certainly the first category is correct, and when I work my way through the exemptions, they're almost invariably public bodies behind which the state stands, and the thinking is pretty plain that the state self-insures.
They're not an insolvency risk.
Exactly. And it's for that reason that you have a different mechanism of compensation in relation to that category of user. That's the first of the guarantee funds. Then you have recital 11. This is the special plate mechanism. And this is a vehicle-based exemption. Now, it's not been used in the UK, but it has been used in other member states. And what this provides is that for certain categories of vehicle, you can issue a special plate. Because that raises cross-border problems, you can see about halfway down the recital 11. However, since the elimination of border controls within the community means it's not possible to ensure that vehicles crossing frontiers are covered by insurance, compensation for victims caused abroad cannot be guaranteed. Steps should be taken to ensure that due compensation is awarded to the victims of those accidents caused by those vehicles, not only abroad, but also in the member state in which the vehicle is normally based. Now here's the kicker. For this purpose, member states should treat the victims of accidents caused by those vehicles in the same way as victims of accidents caused by uninsured vehicles. It's plainly a reference to Article 10, and it's the first of a number of indicators that the long phrase in Article 10 is simply a synonym for an uninsured vehicle. Indeed, compensation to victims of accidents caused by uninsured vehicles should be paid by the compensation body of the member state in which the accident took place. Where payments are made to victims of accidents caused by the vehicles subject to derogation, the compensation body should have a claim against the body of the member state in which the vehicle is normally based. So there you have a vehicle that is exempted from the insurance requirement, but treated for the purposes of the guarantee body as an extension of the category of uninsured vehicles, which it is, because it's wholly uninsured under the scheme of the directive. Then we come on to recital 14. This is the key recital because it relates to Article 10.1. And unfortunately, the recitals from here on inwards kind of jump all over the place. They don't work in chronological order. It's necessary to make provision for a body to guarantee that the victim will not remain without compensation where the vehicle which caused the accident is uninsured or unidentified. So again, the second pointer to the fact that uninsured is the correct synonym for the longer phrase in 10.1. It's important to provide that the victim of such an accident should be able to apply directly to the body as a first point of contact. However, member states should be given the possibility of applying certain limited exclusions as regards the payment of compensation by that body and providing that compensation for damage to property caused by an unidentified vehicle may be limited. So please note its language, its contrast between uninsured or unidentified vehicles. Recital 15 then explains the operation of and exclusions contained in Article 13. And then please note recital 16.
That's basically saying no horizontal effect. But that's another reason for no horizontal effect.
I'm not sure I understand my Lord's question.
Well, I'm not sure I do either. Let's just leave that for a moment.
Recital 16 then provides that in order to alleviate the financial burden on that body, that's the compensation body that's just been mentioned, member states may make provision for the application of certain excesses where the body provides compensation for damage to property caused by uninsured vehicles, or as the case may be, vehicles stolen or obtained by violence. And the reference to vehicles stolen or obtained by violence is a reference to the provision made in Article 13.2 bis, that's the second paragraph, which will come. So again, the language is about alleviating the burden on the Article 10 body in relation to uninsured vehicles. Recital 18. Please note how the Article 10 body is referred to as the body which compensates for uninsured or identical vehicles. And that's relevant because this is the language that refers to Article 10.1 bis. So again, another part of Article 10, it's all about uninsured vehicles. Recital 23 then deals with the fact that passengers have been folded in, which is part and parcel of the understanding of the genesis of the case law. And then Recital 34 introduces the complex procedure for cross-border claims. I don't think much turns on the detail of these recitals beyond noting that at recitals 47 to 53, you have a third guarantee institution created. And this is the guarantee institution you go to when the insurance body hasn't timorously responded to a cross-border claim. Now, as it happens, in the UK, the MIB is such a body, having been designated as much by a statutory instrument. It's not part of the uninsured and untraced drivers arrangement. So we've got a third guarantee function and a third potential body. Recital 53 makes it plain again, where it's impossible to identify the insurer of a vehicle in this cross-border scenario, it should be provided that the ultimate debtor in respect to the damages to be paid, to the injured party is the guarantee fund provided for this purpose, situated in the member state where the uninsured vehicle, the use of which has caused the accident, is normally based. So those are the recitals. We then come to the substance of the directive. The chapter headings are, and the article headings are, illuminative aids to interpretation.
Does recital 53 treat as an uninsured vehicle a vehicle which may in fact be insured, it's just that nobody knows who insures it?
No, that would be an untraced vehicle.
No.
No, the vehicle will be traced.
The vehicle's traced. It's burnt out in a field. Somebody's filed all the identification numbers off before using it in crime. All anyone knows is it's a Ford Escort. Can't identify it, can't trace the insurer. On the face of it, this recital treats that as uninsured.
I think
on
it's-
your interpretation.
No, I think it's directed rather at the circumstance where you're looking at the situation where the vehicle is in fact uninsured.
No, 53 relates to cases where it is impossible to identify the insurer. Anyway, there we are. That's
I'll think about
a
that.
quirk of the language.
But it uses the phrase uninsured vehicle at the top of the right-hand column.
Yes, that's the point I was making.
And I think that answers my Lord's question, doesn't it? Which is that a vehicle where it's impossible to identify the insurer of a vehicle is treated as an uninsured vehicle.
Yes.
Does that?
Yeah, even though it is insured,
It may-
potentially.
Maybe. It may be, but it's treated as if, a bit like the special plates.
Yes.
So, you've got the Article 1.3 definition of National Insurers Bureau, which obviously embraces the MIB, and then the core provisions start at Article 3, compulsory insurance of vehicles. And you see, echoing the language of the recital which is picked over, each member state shall, subject to Article 5, take all appropriate measures to ensure that civil liability in respect of the use of vehicles normally based in its territory is covered by insurance. The extent of the liability covered and the terms and conditions of the cover shall be determined on the basis of the measures referred to in the first paragraph. Same answer as to what that means. Provisions will set out the substantive content. And you have, in effect, an obligation to have cover in place with the extent of liability and matters like that being provided for by national law, subject to the harmonised minima about the levels of cover provided by the rest of the directive. Paragraph 3 also shows that effectively it's got to be pan-European coverage.
So could you have a situation where the longer form of words that we find in Article 10 covers a situation where there is a contract of insurance, but its terms don't match up to the prescribed minima? For instance, they cover only some of the EU states, or they don't, in some other respect, comply with the directives requirements.
It's one of the peculiarities, I'll show you this as we look at the other provisions. The only other place where the term uninsured vehicle is used is in Article 15. And the synonym is also used in another place in the directive. Can I just take you through the provisions, and you'll see the point I'm trying to make. So the next thing we need to look at is Articles 5, 1 and 2. Those are the exclusions by reference to the vehicle user and the vehicle type, the special plates exclusions. And you see the special plate scenario is identified at 5.2, page 126. And you can see that that is one of the instances where this long form wording is used. Any member state so derogating by providing for special plates shall ensure that the vehicles referred to in the first subparagraph are treated in the same way as vehicles for which the insurance obligation provided for in Article 3 has not been satisfied. That's exactly the same language as 10.1, and yet it's plainly being used to connote wholly uninsured. There can't be any question about policy avoidance or exclusion or anything of that kind. And indeed, recital 11, which relates to this provision, describes all of this as being about uninsured vehicles. So that's a very strong textual pointer to our approach to what the synonym of a long phrase means. That in combination with recital 11. Then chapter 3 deals with the minimum amounts covered by compulsory insurance. This is not a scheme that has been used by the UK. It has been used by other member states.
the limits. There's limits for properties. It used to be 250,000. Is it still property?
The limits in the case,
Unlimited for personal injury.
unlimited for personal injury. I think that's right. No, not under the directive, but in the UK.
Yes, in the UK.
Yes, in the UK.
Which
it's
is,
unlimited.
which is well in excess of what the directive.
Absolutely. You see the requirements in the directive
Yep.
at the top of 127 first column. In the personal injury scenario, €1 million per victim or 5 million per claim. And in the case of damage to property, $1 million per claim, whatever the number of victims. So those are the minima. Or if you like, the permitted maxima. You never know which way to put the issue. Those are the relevant limits. UK doesn't use those measures, but it's important to be aware of them for this reason. There is quite a complicated provision for the uprating of the relevant limits contained in the balance of Article 9. And one could well imagine a number of potential scenarios arising in relation to that. Either a member state mucks up its uprating or forgets to do it, such that the limit in force creeps below the permitted limit, or they commit some other breach of EU law in the limits they implement. Let's suppose that they implement limits that are discriminatory on grounds of sex or race or nationality or something of that kind. One has seen that from time to time. Some other violation of EU law occurs. On my learned friend's analysis and on the judge's analysis, it's the guarantee bodies that are liable for any such breach of the Article 3 obligation read with Article 9, because they're guaranteeing all of the obligations under the directive. That's just one of the illustrations of the areas that this can break down. Then we come on to the language of Article 10, and you see the long phrase, the vehicle for which the insurance obligation provided for in Article 3 has not been satisfied, has appeared in the title. And that is the second category of case. When you look in 10.1, the first category of case is an unidentified vehicle, no problems there. The second category is a vehicle for which the insurance obligation provided for in Article 3 has not been satisfied. That's our key phrase. Then look at the second paragraph of 10.1. The first paragraph shall be without prejudice to the right of the member state to regard compensation by the body subsidiary or non-subsidiary, and to make the right to make provision for the settlement of claims between the body and the person or persons responsible for the accident, and other insurance or social security bodies required to compensate the victim in respect to the same accident. However, member states may not allow the body to make the payment of compensation conditional on the victim establishing in any way that the person liable is unable or refuses to pay. And then we come on to 10.2, provision that says the victim may in any event apply directly to the 10 body on the basis of information provided at its request by the victim. It should be advised to give them a reasoned reply regarding the payment of any compensation. And then we have the exception here. This is the only permitted exception in relation to the Article 10 body. Member states may, however, exclude the payment of compensation by that body in respect of persons who voluntarily entered the vehicle which caused the damage or injury when the body can prove that they knew that it was uninsured. So what we have is an exception from the obligation to compensate, which applies when you get into a car knowing that the vehicle, not the driver, the vehicle is uninsured. There is no other way to read the word it. It's all about the vehicle, and as we know, EU motor insurance is all about vehicles, where we're more concerned with drivers or users. Indeed, we agree with what my learned friend said at paragraph 63 of his skeleton argument on this provision in relation to the abandoned ground 2. It's all a reflection of the fact that whilst the UK model is focused on whether the driver is insured, the codified directive and the directives that preceded it focus on whether the vehicle is insured. And the problems that that mismatch have caused is illustrated by cases like Churchill, etc. So we accept that Article 10.2 bis cannot capture someone getting into the car knowing that the driver is uninsured. But as I alluded to earlier, whilst we now accept the logic of clarity of the point for the unarguability of ground 2, it actually supports our case that the long phrase is itself a synonym for the term uninsured vehicle, which is uninsured, which is used here. Why is that so? Well, the only purpose of 10.2 bis is to qualify 10.1 and to qualify the long phrase in 10.1, because none of this can be about untraced vehicles. And it seems obvious that there should be correspondence between the material scope of 10.1 and the material scope of 10.2 and the exclusion that it contains. Indeed, we'll see that if that's not the case, and if 10.1 is wider, as my learned friend argues it must be, than 10.2, that leads to a fairly fundamental incoherence in the directive because of the scope of the Joyrider exception in Article 13. It would mean that in circumstances where, according to my learned friend, the guarantee body is liable to pay in relation to a car that was insured, but where the policy of insurance has been avoided, the guarantee body would not be able to avail itself of the Joyrider exception, because the only exception available to it is the one contained in 10.2 bis.
Could you say that again? I'm being very slow today, but could you just repeat that submission, because I'm not sure I understood it.
So, in circumstances where, if my learned friend is correct, the scope of Article 10 embraces the third category of case, of a policy being avoided on the basis of some impermissible exclusion, you would have a scenario where the guarantee fund would be unable to take advantage of the Joyrider exception that was available to the insurer. The insurer can, and we'll see in a second, the only permitted exclusion of liability is where somebody gets into a stolen car knowing it to be a stolen car. But there's no trace of that here. The only permitted exclusion for the guarantee fund is if someone gets into a car knowing that it's uninsured. That's very different. Most of the time, joyriders get into cars that are insured. So the problem is, once you expand 10.1 to embrace something other than an uninsured vehicle in the 10.2 sense, the exception contained in 10.2 is incoherent. Then you have the Article 11 provisions, which deal with a situation where there is a dispute between the 10.1 body and the civil liability insurer as to which must compensate the victim. And the obligation is to make sure that at least one of them is designated as the default body in the first instance. It doesn't specify which of the two is to be the default party. And that's obviously to cover a situation where, for instance, there's a dispute as to whether or not the car in the accident was one that was insured by insurance company A or some other untraced car, or a dispute as to whether or not the car was in fact insured at the time of the accident. Certainly doesn't cast any light on the scope of Article 10.1. Then we have Article 12, which folds in all passengers, codifying in effect the effect of some of the case law as well. And then we have Article 13, exclusion clauses. Now, the peculiarity of this provision is that if you come to it as an untutored neophyte, like I was until relatively recently, you might be forgiven for thinking that this is the totality of the exclusion clauses that are prohibited. But that is not the effect of the case law. In effect, the list of prohibited exclusion clauses is merely indicative of a much wider and more fundamental prohibition on exclusion of liability, as identified in the Reyes-Benaldes case and following. What the real significance of Article 13 lies in the last paragraph at the foot of the first column, because in fact its main significance now is to identify the one category of case where you are, as an insurer, permitted to exclude liability, or as a state to provide for a permitted exclusion by an insurer. And it's where somebody has voluntarily entered the vehicle which caused the damage or injury, when the insurer can prove that they knew that the vehicle was stolen. That's the Joyrider exception. And here you can see that there is the option in Article 13.2 and 3 to move the problem of stolen cars and joyriders into the guarantee fund. So in the case of vehicles stolen or obtained by violence, member states may provide that the body specified in Article 10.1 is to pay compensation instead of the insurer under conditions set out under paragraph 1 of this article. Where the vehicle is normally based in another member state, that body can make no claim against anybody in that state.
Does stolen mean stolen, or does it include taken without consent?
I think it probably must include taking without consent, yes. I think it does. I'm not sure that there's any case law on that.
My Lord, I'm involved in that very dispute in another case called Greenaway, where the difficulty arises. There was no possibility to have a reference to the CJEU on that point, and so Mr. Justice Martin Spencer made an order inviting the parties to effectively submit all different national legislation dealing with the definition of stolen, to assist the court in informing the court as to what it might mean in the particular context and the purpose of interpretation. So the case hasn't come to trial yet, but the issue is the subject of the application for expert evidence, and the case is called Greenaway. If you're minded to look it up on the internet, you will see that the issue of stolen is very much at the heart of that case.
Thank you.
I think as a matter of days ago, I've just been instructed in that case, but I can say with some safety I know absolutely nothing more than what my learned friend has just told me about it. But I think I am right in saying that there is no domestic or CJEU case grappling with that express issue. I'll be corrected by Mr. Mead, who's a font of all knowledge on these things.
My Lord, no. I mean, we are dealing with it.
Yes, it's
virgin territory to be
new territory
traversed.
Yeah,
right.
Indeed.
All right, thank you.
But what is interesting about this provision, enabling those problems, which are obviously the sorts of common risk that might be catered for by a parafiscal taxation scheme, because ultimately the theft of vehicles is not something within the direct control of insurers. What's interesting about that is it's a plain pointer to the type of thing that goes into the Article 10 fund, or potentially does so. And what's more, it's also a pointer to the types of language that might be required in order to widen the scope of Article 10.1. It suggests that absent such an express designation or allocation of function, there is otherwise no form of general underwriting of Article 3 and 13 by Article 10. So if the Article 10 body is to have a wider role in relation to Article 13 issues, it must be expressly imposed on that body by the member state exercising the powers available to it under the directive. Then Article 13.3 is the prohibition on exclusion of liability in relation to a passenger getting into a car of a drunk driver. That problem has inspired a number of the cases, not least Ruiz, Bernaldez and Candidate. Article 15 is also of relevance. Article 15.1 deals with the problem of cross-border dispatching, and effectively it's a conflicts rule to identify which relevant body is going to respond. And then 15.2, in the event that the vehicle is involved in an accident during the period mentioned in paragraph 1, whilst being uninsured, the body referred to in Article 10.1 in the member state of destination shall be liable for the compensation provided for in Article 9. That is the only other place that I have managed to detect beyond Article 10.2, paragraph 2, where you have the plain language of uninsured vehicle in the language of the directive. It's all over the place, time and time again in the recitals, but that's the only other place in the body of the directive.
None of, correct me if I'm wrong, but none of the references to the word uninsured that you've given us assist on the, just textually, on the impact of avoidance ab initio.
No, because the issue of that scenario, after the travaux préparatoire, has never been directly engaged with by either the second directive or this directive. And what happened, as we'll see, is that the travaux anticipated the creation of a third category by the Commission, and that third category was excised by the Council, that instead interposed Article 13, as it now is.
So you rely on the travaux as rather than the actual text, freestanding text of the article, as indicating what is meant.
Well, the critical thing from the travaux is actually the genesis of Article 13 that is the answer to the problem, and the very narrowness of the sole permitted Joyrider exclusion. And that tells you that effectively the problem of avoidance is to be dealt with by Articles 3 and 13 and not by Article 10. So, standing back, what you get from reading the codified directive as a whole, even on its own, is I would submit this. Firstly, there are three main compensation or guarantee functions under the directive. There's the Article 5.1 exempted vehicle function, state-backed payment, if you like. There's the Article 10 compensation function, and then there's the Article 25 function, where you see, I didn't take you to 24 and 25, but they provide for the compensation bodies anticipated by recitals 53 and thereabouts, the cross-border compensation. And in fact, there's actually a fourth function anticipated, which is the information provision function in Article 26 for the central body. And in the case of the UK, I think I'm right in saying that that's done by a subsidiary of the MIB. That's the first thing you get. 4 identifiable functions, 3 of guarantee, 1 of the central information centre. The second thing you get is that all of the material recitals, time and time again, when referring to the guarantee body and referring to its function, Article 10.1, under 10.1, refer to it as doing so in relation to uninsured vehicles. In short, treating the long phrase as no more than a synonym for an uninsured vehicle. And it's well established that recitals are a proper aid to interpretation of EU legislation, not least because their whole point is to explain the object and purpose of the legislation in question. And then thirdly, the reading that we urge upon you in relation to Article 10.1 is supported by Article 10.2 bis and its reference to a vehicle which is uninsured, which we are all agreed, including the respondent, means a vehicle that was not covered by any policy of insurance at the time of the accident. And you have my point that without symmetry between 10.2 bis and Article 10.1, there is an incoherence. So even before you get to the travaux, my next topic, there's compelling textual support for the argument we just made. What then of the travaux, topic 2? This is covered in paragraphs 27 to 37 of the skeleton argument. The relevant travaux related to what was eventually Article 1.4 of the second Motor Insurance Directive, which became Article 10.1. And we can start with the Commission proposal in the first authorities bundle at tab 15, page 170. There's a whole bunch of other legislative proposals before we get to 170.
Hold on. Tab 15.
Tab 15, page 170. You'll see it's headed Proposal for a Second Council Directive on the approximation of the laws of the Member States.
Thank you.
Back in the day, they didn't number the recitals, but please take it on trust that if you ran 1, 2, 3, 4, 5 from the first whereas, it would be recital 6. That's the first one in the top right-hand column. And you can see here, first, whereas it's necessary to make provision for a body to bear secondary liability for the payment of compensation in cases where the vehicle responsible is unidentified or uninsured, or where the insurer is entitled to disclaim liability, whereas this latter case must be treated in the same way as a case of non-insurance. And then you have that reflected in the text of what was then to be Article 1.3. Each member state shall make provision that compensation within the limits authorised by paragraph 2 for damage to property or personal injuries caused by an unidentified vehicle, and then it's plain that the words or vehicle or uninsured vehicle or something of that kind have been omitted. You'll see that from later drafts. It's just a drafting slip, in respect of which the insurance obligation provided for in paragraph 1 has not been satisfied, shall be borne by a body set up or authorised by that state. And then Article 2 provided, for the purposes of Article 1.3, where an insurer refuses to make payment by virtue of the law or of a contractual provision authorised by law, the vehicle shall be treated as an uninsured vehicle. So, a clear intention to create a third category of case to be covered by the guarantee body of avoidance or exclusion. That proposal was then amended by the Parliament, and you can see the form of amendment in tab 17 at page 293. And what happens is that effectively the language of 1.3 as it was to be is altered. What was the clear third category in Article 2 is deleted.
Sorry, which page are you on?
Page 293.
Thank you.
And it's replaced with the first version of what became Article 13. see they've added in the words that I said were omitted, or uninsured vehicle, being added in, tidied up. So what you have is the problem.
Just hold on a second. I haven't seen this side by side. So instead of a provision which covers any ability to avoid or exclude, you have the three subcategories in the right-hand column.
Exactly. Instead of a solution that ultimately says, if you exclude, it folds back into the guarantee body, you have a solution that says, exclusion is prohibited. And what you have in Article 2 is the precursor to a pretty close degree to what is now Article 31. Now, as we explained in paragraph 31 of Article 2, the Commission continued to fight for its structure. It continued to fight for this residual avoidance category. And you can see that from tab 19 starting at page 421. And in particular at the foot of 421, you see, however, the Commission has amended its proposal in line with the Parliament and EcoSoc by accepting that Member States may, if they wish, exclude or limit payments of compensation by the Guarantee Fund in respect of damage to property. So they conceded that
I'm terribly sorry to be so slow. What's the reference you're at now?
19,
Thank you.
starting at page 421.
Thank you.
So you can see they give up the argument in relation to property. There's been a dispute about whether or not that was going to be included or not. Then over the page at 422, paragraph 3, you can see, all a bit lines up, the Commission nevertheless feels it's essential to retain the principle of treating as cases of non-insurance those residual cases in which the insurer can avoid payment of any compensation to the victim, claims invalidated by false declaration of risk, damage caused intentionally in France. This hypothesis relates to Article 1.3. So they're fighting the good fight for the third category. And then if you go on to page 424, you see that they propose amendments to the relevant recitals to add that back in, and you see that from the new proposals in the underline. First one deals with property, but the second one deals with the disclaimer, which must be treated as instances of non-insurance. And then you can see that that is then traced into the Commission's proposed content of Article 2. So they build on the text that's been proposed at 426, but then they add a rider to it at the top of 427, where an insurer refuses to make payment by virtue of the law or another contractual provision authorised by law, the vehicle shall be treated as an uninsured vehicle. That's the proposal.
So that's an attempt to reintroduce.
Exactly. And that second proposal was rejected. The directive instead was adopted in the form that you find in tab 8 of this bundle. And you see the eventual relevant recital on page 87. Again, if you add the numbering, starting with the first whereas, recital 6. Whereas it's necessary to make provision for a body to guarantee that the victim will not remain without compensation where the vehicle which caused the accident is uninsured or unidentified, whereas, etc., etc., etc. And you see the final form of Article 1.4 on page 89. Including the language caused by an unidentified vehicle or vehicle for which the insurance obligation has not been satisfied.
There's got to be a reason why they use that old phrase. What is it?
Don't know. Genuinely don't know. Article 2. We'll come on to see how these travaux have been looked at by both Advocate General Lenz in Ruiz Benaldez and by Advocate General Mengozzi in Sonka. Article 2 then is in the form that's familiar from an Article 13 perspective. And here you see the only concession made, or any change made, is from the version preferred by the Parliament and the Council, is the Joyrider exception, which is now inserted.
Sorry, you've gone too fast, Mr. Delamere. What page are we on now?
90.
90.
Yeah, so 1.4 is at 89. That's what becomes Article 10.1.
Yep.
Article 2 is what becomes Article 13. And you see that from the form considered in the various proposals, what's been added is the paragraph, however, the provision or clause referred to in the first indent may be invoked.
Yeah.
Etc.
Thank you.
So that's the first appearance of the Joyrider exception. Now, put all that together, it's the plainest possible rejection of the notion that the purpose of the Article 10 body was to guarantee, even in the case of permitted avoidance, still less in the case of avoidance that was incompatible with the directive. And for that reason, having been through those materials, we suggest that the position, as summarised in paragraph 37 of our skeleton argument, is plainly correct. That's tab 2, page 36. The legislative history of what is now Article 10 shows a significant and deliberate contraction in the Article 10 body's remit in comparison to the original response. It's undeniably the case based on these materials. And what's more, that legislative history fully supports what we say is now fully reflected in the recurrent express terms of the recital. The problem that's been directed at it is that that did, at least for a time, lead to a potential lacuna in the protection of victims. If avoidance were permitted on grounds not directly addressed by Article 13, which had prohibited, then that might create a lacuna. As we shall see, that lacuna was closed in a completely different way by the court saying that Article 3, read with Article 13, prohibited any form of exclusion, bar the Joyrider exception. Topic 3, I can take this very quickly, domestic implementation.
Can I just note that last point? Could you just give me that last point again? The lacuna was that if avoidance was permitted.
If avoidance was permitted, you would have a situation in which somebody, in relation to which there had been an insured vehicle, who was a victim of the accident, nevertheless, through no fault of their own, none of their own conduct or anything of that kind, could find themselves without an insurer to have recourse against, and without access to the guarantee fund. And that would lead to a gap in the protection required by the directive. But the way that that problem was addressed was by expansively interpreting Article 3 and 13 and the prohibition on exclusion of or avoidance of policies. And that, the Ruiz Benaldez and Candlin line of case law, closed any such lacuna. And it's notable, when we go through the case law, you'll see time and time again the Commission tries to revive its arguments about the breadth of the guarantee fund as the solution to the potential lacuna, and the court says no. The solution is in Article 3, as now is, and 13. So, domestic implementation. I'll take it very quickly indeed. The RTA, as currently enforced, is in Authority Bundle 4, tab 4. Mercifully, we don't have 4 Authority Bundles. I've got section 95, which contains the definition of authorised insurer, which is the bedrock of the special powers that leads to the emanation of state analysis. It's an insurer who's a member of the MIB. We've got the core obligation of mandatory insurance, and the core problem that's created by VNUC, the mismatch between the obligation of 143 and the obligation under Article 3, because Article 143 says that a person must not use a motor vehicle on a road, whereas VNUC comes along and says it's anywhere, unless there is enforced in relation to the use of the vehicle by that person such a policy of insurance as complies with the requirements of this part of this Act. So that's the source of the mandatory insurance obligation. Section 144 contains the Article 5.1 exceptions, and my Lord can look through it and see if it's as he remembers it. I didn't get much beyond the council or county council, fire and rescue, ambulance services, etc. That's the Article 5.1 exception. Section 145 then specifies the contents of the mandatory policies of insurance. And this is part and parcel of, again, giving effect to the requirements of Article 3 and 13. Critically, you can see at 1452, the policy must be issued by an authorised insurer. And it's that provision, combined with section 95.2, that then gives the MIB the ability to levy road traffic insurers for the funds required to pay out to the untraced or uninsured driver victims. And you can see at 1455, page 35, authorised insurer has the same meaning as section 95. (148) at 37 is the first part of giving effect to Article 13, and it controls or prohibits certain exclusions or exceptions. 151, the old version of which you'll find at tab 2, page 6 to 8, contains the duty to satisfy a judgment, giving effect to Articles 13, 1A and B, amongst other things. But that's all subject to the old section 152, which you have at 9. You can see just under superseded the version 6th of April 2013 to the 29th of June 2015. That's the material version in force at the time of the relevant accident. The critical thing to note is subsection 2, subject to subsection 3, no sum is payable by an insurer under section 151 if an action commenced before or within 3 months after the commencement of proceedings in which the judgment was given, he's obtained a declaration. So under the old form, you could commence your application for a declaration well after the accident in question.
Well, that was normally what happened.
Yes.
Accident, claim, whoops, how do we get out of this one?
Exactly.
Application under section 151.
Yes.
I mean, I don't mean that pejoratively, although it might possibly have sounded pejorative. But it's,
No, it's no more than the insurers looking after the fiduciary duties that they bear towards the various people to exercise whatever lies in their power to avoid liability.
one way of putting it.
That's how insurers act. But the version in force from now, 21 onwards, you can see it's the 1st of November 19 onwards, contains a materially different section 1522. That's at page 25. No sum is payable by an insurer under section 151 in connection with any liability if, and here's the critical word, before the happening of the event which was the cause of death, the insurer has obtained a declaration. So you can only now get such a declaration before the relevant accident. Well, those changes were made by 2019 regulations that you'll find in tab 6.
And your submission would be that that brings it in line with your interpretation of the directive, because it means that at the date of the accident there is no policy.
There is no policy, and it's clear. It's clear whether the car is insured or not. You know in advance, while you're driving the car, whether there is in force a policy or not.
And could you just remind me what was the case that highlighted the non-compliance of the previous version?
Well, it's both Delaney and Road Peace, but it's in particular in Road Peace a concession was made to Mr. Justice Ousley. Yeah. I'm going to show you that in due course. Yeah. The relevant amending regulations are at tab 6, page 44. The relevant provision amending section 152 is regulation 6, page 47. You can see the explanatory note in relation to that is at page 74. Doesn't say very much other than it's to limit the rights of the insurer to rely on having avoided an insurance policy after an accident. Slightly more informative is the explanatory memorandum rather than explanatory notes, which was produced. You'll find that in the second authority bundle at tab 47. In particular, if you turn up page 1204, paragraphs 6.2 and 6.3. In the Road Peace JR, we inform the court we'd amend section 152 because it is incompatible with EU law. This concerns an insurer's ability to rely on having avoided a policy after an accident to deny compensation under the RTA to third-party victims. And that's no doubt why the powers exercised to make the 2019 regulations are both section 2.2 of the European Communities Act and powers under the Road Traffic Act. So that's the domestic legislation.
Where's the passage you just referred to?
Page 1204, madam. Paragraph 6.2.
Thank you.
And 6.3, dealing with Northern Ireland.
Got it.
So let me go and come to my topic 4, the Article 13 cases. It's these cases that address the problem of the potential lacuna in protection. It didn't take that long for the problem to come up. The first case where the problem came up is Rees Bernaldez, and that's in the first bundle of authorities at tab 23. Both this case and the later Candidate case arose in the context of accidents caused by drunk drivers. I think it's fair to say the main material difference between Rees Bernaldez and Candidate is that the victim in the Rees Bernaldez case had nothing to do with the drunk driver. They were a bystander. Whereas in Candidate, all the passengers in the car had been on a drinking binge together. And the party bringing the claim was one of the drunks who'd got into the car with the drunk driver. basically a Finnish provision that led to a kind of axiomatic exclusion of liability in those circumstances, a kind of rule of presumed contributory negligence. So res penalties. Here, the insurer sought to avoid the policy in question because of the drunkenness of the driver. You can see that at paragraph 3 of the judgment, page 531. And that led to the questions that were referred at paragraph 5. Can I ask you to note the following about the questions referred? Questions 1 to 4.
Not until I've got there, please. Mr.
Page
Chairman.
532.
Yes. Just, if I may say so, speaking for myself, I'm finding it quite difficult to keep up with making a note of these submissions. So perhaps you could just give us a bit of a pause as you bound from one page to another.
I'm so sorry.
Thank you. Yep.
So you can see the 5 questions referred. The first 4 questions are all about what are now Articles 3 and 13. Article 3 of the first directive is the equivalent of Article 3 of the codified directive. And Article 2.1 of the second directive is what we've just been looking at. It's the equivalent of Article 13 of the codified directive. We've got 4 questions about Articles 3 and 13, as that is, and then a 5th question, which is about Article 1.4, which is now Article 10. And the 5th question alone asks about the guarantee fund. The court, as is its habit, reformulated questions 1 to 4, paragraph 9, and said, effectively, those questions all run together, and they really ask whether, without prejudice to the provisions of Article 2.1 of the second directive, a compulsory insurance contract may provide that in certain cases, in particular where the driver was intoxicated, the insurer is not obliged to pay compensation for the personal injuries and damage to the property caused to third parties by the insured vehicle, or whether, in the alternative, in such cases the compulsory insurance contract may provide only that the insurer is to have a right of recovery against the insured. Can I then ask you to note the position of the United Kingdom and the Commission at 10 and 11? The Spanish and Greek governments, the UK and the Commission, consider that the directives leave member states a wide discretion with respect to the terms and conditions of compulsory insurance, but they must ensure in any event that the victim is compensated, either in all cases or at least in the principal fields of civil liability, in particular where the damage is caused by a vehicle driven by an intoxicated person. Those 3 governments consider that the directives authorise exclusion clauses relating to the physical condition of the driver, provided that they only take effect between the insurer and the insured. So you have the UK, Spain and Greece saying exclusions are permissible, but only as between the insurer and the insured. And then on the other hand, you have the Commission in 12 reviving its favoured technique. In the Commission's view, on the other hand, the directives authorise such exclusion clauses, even in the relations between the insurer and the victim, on condition that the vehicle is then treated as an uninsured vehicle, and the body referred to in Article 1.4 of the second directive compensates the victim. So the court was effectively being presented with a choice between 2 solutions. And the solution chosen by the court at paragraph 13 and following, and culminating in the core purposive effect, effectiveness reasoning at 18, 19 and 20, is to conclude that Article 3 of the directive does indeed, in paragraphs 20, preclude an insurer from being able to rely on statutory provisions or contractual clauses to refuse to compensate third-party victims.
Could you pause for a moment while I just read 18 to 20, because I haven't written
Of course,
that.
madam.
So that's purely as between insurer and victim.
Absolutely. At 21, they emphasise that the only derogation permitted from that core obligation is in relation to the Joyrider exception. See that at the foot of 21. And then at 22, they endorse the position of Spain, Greece and the United Kingdom that that does not preclude a statutory provision or contractual clauses under which it's possible for the insurer to claim against the insured. So what you have, in plainest terms, is the rejection of the Commission's invitation to solve the problem by opening out the scope of Article 10.1, as now is, of the directive. That is rejected out of hand by the court. And for that reason, the court does not answer question 5. You see that at paragraph 25. And 26. In view of the answer to questions 1 to 4, there is no need to answer question 5. Now, I must show you, because it featured prominently in the judgment below, the approach of Advocate General Lenz. Because he concurs completely with the court's analysis of questions 1 to 4, but being a thorough Advocate General, and Advocate General Lenz was nothing if not that, he also answers question 5 in the alternative.
Hello. Thank you. Yep. That page.
That relevant analysis starts at page 528, question 5.
Thank you.
And he points out at 43 and 44 that this question only arises if his answer to the first 4 questions is rejected. And then he says, if the court should not, halfway down 44, not adopt that line of argument, question 5 might be considered in the alternative. Then at 45, he points out that the premise of the question is a most unlikely one. Because it's going to turn on the victim himself being guilty of blameworthy conduct. (46) He says, apart from those highly exceptional cases of the victim's own blameworthy conduct, it must be assumed that there is a need to ensure that there are no gaps in the duty to compensate the victim. So here we have the there must be no gaps analysis. That principle can be seen to be the guiding principle of the directives. And it's that guiding principle that's been drawn upon by my learned friend and the learned judge below to expand again the compass of Article 10.1. To that effect, the National Guarantee Body must be regarded as a means of covering accident victims who would otherwise be unprotected. The reason for requiring such a body to be established is the concern to protect victims. And at 47, he says how the duty to provide compensation is actually to be allocated is at least partially in the discretion of the member states. And then at 48 and following, he goes through some of the travaux that I have just shown you. 50, he says, the proposal did not survive in the council, and it was replaced with Article 1.4 as now in force. The wording 51, finally adopted, and the provisions legislative history show that the body is in no way conceived as a general catch-all, providing compensation upon the occurrence of any excluded event. Nor does the provision simply refer to the absence of insurance, to which the National Court alludes. Everything therefore indicates that within the framework established by the directive, the person who has suffered harm as a result of the accident must recoup his loss from the insurer. And then there's this passage, which I think is the passage upon which my learned friend relies particularly. Only if, for whatever reason, he has no claim for compensation against an insurer, would the body have to pay compensation in the interest of the extensive protection of victims. Furthermore, the member states are free to extend the competence of the body by statute, provided complete protection is ensured for the victims. Now, a couple of problems with that analysis. Firstly, it's plainly rejected by the court. And you've seen how the court approached the Commission's submissions in contrast to the United Kingdom's submissions and rejected them. The court located the solution exclusively.
The premise is rejected by the court.
I'm sorry, Ronald?
The premise is rejected by the court.
Yes. The premise that there's
They
any.
don't actually comment on his logic if his premise had been correct.
I think that's fair, yes. I think that's fair. But secondly, what we'll see is that when the problem resurfaces in cases like Sonka and Fidelidade, the Advocate General Lens solution is not adopted in the case number. And his approach is to be contrasted with Advocate General Mengozzi's in Sonka. So that's Advocate General Lens's opinion. And whilst Advocate General Lens is, I think it's fair to say, one of the most respected Advocate Generals in the history of the court, it's still only an Advocate General's opinion, and the law is located in the judgments of the court. Then we have the case of Candlin, tab 24. Very similar fact pattern.
I haven't read this either, so you have mercy at critical moments.
Well, my Lord Justice Holroyd's very polite admonishment firmly in mind, so I'll try and keep it slow.
Who was the defendant in the Candlin case?
In Candlin, you can see the essential facts in the court's judgment at paragraph 10, page 552. And here, Mrs. Candlin had been travelling in a car with Mr. Villanieni and Mr. Parnanen. Mr. Parnanen's car was driven by Mr. Ruakororanta. During the journey, an accident occurred causing the death of Mrs. Candlin as well as serious injuries to the others. It's apparent from the order for reference that the driver and all the other passengers were drunk. So this was a context in which the issue, somewhat anticipated by Advocate General Lens in Rees Ben Albez, of potentially blameworthy conduct on the part of the passenger and therefore the claimant, did arise.
That means that Mrs. Candlin was drunk as well, does it?
Yes.
All the other passengers?
Yes.
Treating the driver as a passenger in the car?
Yes. Both. She wasn't the driver. She was a passenger.
No, but the
owner of the car was also
passengers. Doesn't mean all the other passengers apart from Mrs. Candlin.
No. No, you see that from the ensuing facts, because the whole basis of the objection to paying out to Mrs. Candlin was that she was drunk, got into the car drunk, and knew that the driver was drunk. And you see the questions referred at 15, and the critical question, or aspect of the question, is at 15.2. Is it consistent with community law in any situation other than the cases mentioned in the second subparagraph of 2.1, that's the Joyrider Exception, to exclude or limit on the basis of the conduct of a passenger in a vehicle his right to obtain compensation from the compulsory motor insurance for road accident damage. May that come into question, for example, when a person has entered a vehicle as a passenger, although he could have seen the danger of the accident and his suffering, if injury, was greater than normal. In other words, getting into a car with a drunk driver. The questions are again rolled up in paragraph 16. And at paragraph 17 through to 23, you get, in essence, a straight repetition of the reasoning in Ruiz Benaldez, save with one important difference. It's plainly now extended to a passenger who is in some way potentially blameworthy. The reason I emphasise that is it was that extension, as we'll see, that was the material extension on the facts of Delaney. Because in Delaney, the car in the crash was awash with cannabis. There was some suspicion that the driver was a dealer, or they were both dealers, and the driver was a habitual user of cannabis, and that was known to Mr. Delaney. And then what is new, but not material for our purposes, is the argument made by the Finnish guarantee body and various governments that community law doesn't impose any limits on the appraisal of contributory negligence, and therefore an axiomatic contributory negligence rule was permissible. And that argument, you see at 26, was rejected. You can't have contributory negligence rule 29 operating by general and abstract criteria. It's got to be individual assessment. So that's canon. Now, as a result of that case, the law was very clear under Article 13. It was impermissible on any grounds, even grounds as stark as the conduct of the passenger in getting into a car with a knowingly drunk driver. It was impermissible on any grounds to exclude or avoid liability. That's the first thing that was clear beyond argument. The second thing that was clear beyond argument is that there was only one permitted exception to that general rule, and that was the Joyrider exception. That much has been clear since 2005. And the result of those cases is that the lacuna, or potential lacuna in protection under the directives, has been closed. It has been closed by an expansive interpretation of Article 3 and a narrow interpretation of Article 13. And the invitation to close the lacuna instead by an expansive interpretation of Article 10.1, the Commission reviving its proposal, was rejected. That's why we say, and we'll say even more so than Delaney, that it's plain that the answer to this case is a Frankovich claim, and it's plain that the terms of Section 152 long contravened the requirements of EU law.
Say that again. That's why it's plain that the claim.
That's why it's plain that the requirements of Section 152, it's plain what the requirements of Sections 3 and 13 have been since 2005, And it's been plain since 2005 that Section 152 contravenes those requirements.
As it was.
As it was. Now, all of these authorities were reviewed by Lord Justice Ouseley in the Roadpiece case. Can I just show you that? Authorities Bundle 2, tab 42. Roadpiece was a case in which a national charity which provided support for road crash victims and which sought to improve road safety brought a challenge in relation to quite a wide range of numbers in respect of which it said that the Road Traffic Act did not comply with EU motor insurance law. Part of the challenge was directed at the VNUC case and the non-compliance of the RTA with VNUC. That's not relevant for our purposes other than by way of background. Part we're concerned with is identified at page 1068 as being the first group of issues. And it relates to, see this at paragraph 5 at 1068, in the judgment of Mr. Justice Ouseley. It relates to the compatibility of the UK statutes with the Directive sections 143, 145 and 151, an allied provision which permitted insurance policies to include limitations and exclusions on the use insured, such as confining the insured use of the vehicle to social or domestic use. And that group of issues, after recitation of the relevant provisions of domestic law at paragraph 13, including section 151, the Joyrider Exception, etc. That first group of issues is then dealt with at 1073. Now, the case that Roadpiece was making was effectively that it was inconsistent with Articles 3 and 13 of the Directive to include the common forms of restrictions that you see, such that you use a car only for personal use purposes, or that you authorise it for use as a PHV, a private hire vehicle, or something of that kind. Different types of use attracted different insurance and different premium. And they said that was inconsistent with the requirements of the EU. And it was in that context that Mr. Justice Ouseley reviewed all of the case law I've just shown you, including Bernaldez at 28, Candelin at 32, the Churchill case at 33, and at 41 to 43, the case of Shuker. Now, I'll come back to that case, but you'll see that in effect, in common with the court in Delaney, the judge accepted that Shuker was only about insolvency and therefore didn't bear upon the Article 3 issues because the court had decided the risk of insolvency wasn't one of the things, of the insurer, wasn't one of the things addressed by Article 3. But what you also get is that late in the day, the Fidelidade case landed. I think it was in the course of, I think it was even after the oral argument. You see at 70, page 1086. A further issue arose, which is usefully picked up here. Mr. Palmer accepted in his written submissions of October that the true effect of Fidelidade was that section 152 of the RTA was no longer compatible with EU law. The general rule is that the insurer is directly responsible for satisfying judgments. There was an exception to that rule in 152, where a declaration had been made that the policy had been obtained through non-disclosure. Amendment would therefore be required. But that was not part of the challenge in these proceedings, nor did it relate to these grounds, which is why it wasn't part of the declaratory relief eventually granted in this case. in relation to the parts which succeeded, which was the Uk challenge. So that's how Fidelidade crept in. But what is absolutely apparent is that the judge, in reading the line of case law in Ruiz Bernaldez, Candelin, etc., read it in exactly the same way that we'll see Mr. Justice J read it in the case of Delaney. A clear bar on exclusions. Not one, he held, that extended to controls on various types of use, which he found to be consistent with the directive. Now let me come to the 4 key cases.
No, hold on. Could you just give us the reference to where he deals with that? Because you're not taking us to it now, which means, I suppose, you want us to read it at our leisure.
I know my lord gets no leisure, but I am asking you to read it later.
Still got to read it.
Yes. So the critical conclusions are, I think, at 64 through to 70.
64 to 70.
Yeah, so everything that comes before that is a review, a very careful review of the case law. Then at 64 to 70, he concludes that Mr. Hyam's case, that it's inconsistent with the directive to limit various uses, fails.
Thank you.
So Sonka, tab 28, which is in the second authorities bundle, same authorities bundle we've just been using. Sonka was a case where there was an insurer, Hungarian insurer called MAV, had insured a number of parties who'd been successfully sued by victims for the damages that they'd caused in road traffic accidents. However, MAV went into insolvency. And under Hungarian law as it existed at the time, the Article 10 body had no liability for any such insolvent body. As it happened, in Hungary, as a top-up to the Article 10 functions, such a guarantee of the insurer's solvency function was added as a matter of Hungarian law. And again, as a matter of exactness.
But it didn't, not imposed on the Article 10 body.
Yeah, it wasn't an EU obligation.
No.
There is a current proposal for an amendment to the Motor Insurance Directive live in Europe at present, which obviously, for reasons I don't need to explain,
So who was the
the
insolvency risk? Could you just remind me who the insolvency risk was placed on?
Originally, the insolvency risk fell on the victim. If the insurer was
You
insolvent.
said the Article 10 body had no liability in Hungary. Hungary happened to impose the insolvency risk.
Later, after the facts of his case. And it was no doubt that fact that prompted the argument again. As it happens, there's now a proposal to amend the codified directive to add to the functions of the Article 10 body underwriting insolvent insurers. So that function needs to be added by the proposal being considered by the EU, along with proposals to amend the scheme to take account of and undo some of the effects of FNUC. So what happened was that the insured parties who had been less exposed by MAV's insolvency then brought a claim for damages against the Hungarian state for its failure to require the guarantee body to guarantee against insurer insolvency. And they relied upon the wide words of Article 10.1 in much the same way that my learned friend does and the judge accepted below. And you can see this from the CJEU's judgment, paragraph 18. And 19, they brought an action for damages against Magyar Alam, which is not the guarantee body, it's actually the Hungarian state.
Right, page, please.
Page 726.
Thank you.
And in foot of 20, you can see how they put their argument. They argue that by not taking the measures necessary to ensure but in the same circumstances as was provided for by the later law, compensation was paid by a body providing compensation where damage took place before that date, the Hungarian state had acted in breach of its obligations under EU law, in particular Article 3 of the First Directive, thus incurring liability itself. So it was a Frankovic claim against the Hungarian state for its failure to ensure that the guarantee body provided protection against insolvency. Again, the CJEU recast the questions at 22. And they answered the question so recast at 23 to 28. And the answer, you see at 28, is not one that requires protection against insolvency. Then at 29 to 30, they address the guarantee fund. You see the importance attached by the EU legislature to the protection of victims is evident under the second directive from the establishment of the body with the task of providing compensation, at least up to the limits provided by EU law. In order to alleviate the financial burden to be borne by that body, member states were free to exclude the payment of compensation by it in certain cases, or to provide for excesses. The payment of compensation by such a body is therefore considered to be a measure of last resort, envisaged only for cases in which the vehicle that caused the injury or damage is uninsured or unidentified, or has not satisfied the insurance requirements referred to in Article 3.1 of the First Directive. As regards the determination of the actual circumstances in which Article 3.1 may be regarded as not having been satisfied, it is significant, as the Advocate General stated in point 32 of his opinion, that the EU legislature did not confine itself to providing that the body must pay compensation in the event of damage caused by a vehicle for which the insurance obligation has not been satisfied in general, but made it clear that this was to be the case only in relation to damage caused by a vehicle for which the insurance obligation provided for by Article 3.1 of the Directive has not been satisfied. That is to say, a vehicle in respect of which no insurance policy exists. Such a restriction, that's i.e. the restriction to a vehicle for which no insurance policy exists, is explained by the fact that Article 3.1 of the First Directive, as has been pointed out in 28 above, requires each member state, subject to the permissible derogations, to ensure that every owner or keeper of a vehicle normally based in its territory takes out a policy of insurance for the purpose of covering, up to the limits established by EU law, his civil liability. Viewed in that light, the very fact that the damage has been caused by an uninsured vehicle attests to a breakdown in the system which the member state was required to establish and justifies the payment of compensation by a national body. 32, and this in our submission is the critical passage, it follows from the foregoing that contrary to the line of argument put forward by the applicants in the main proceedings, payment of compensation by such a national body as provided for under the first and second directives cannot be regarded as the implementation of a guarantee scheme in respect of insurance against civil liability relating to the use of motor vehicles. Rather, it is intended to take effect only in specific, clearly identified sets of circumstances. The insolvency of the insurer does not constitute a case which can be identified as one of those circumstances. In such situation, the insurance obligation has been satisfied. That's the critical thing. If the car has been insured, even though there is no payment out, the insurance obligation has been satisfied. Now, there are passages in that collection of reasoning that I accept are somewhat Delphic. It's not hugely clear, but that is often the way with CJEU judgments, product of the committee drafting that they necessarily are. And it's in those circumstances, particularly when the text of the judgment points you to the relevant analysis in the Advocate General's opinion that is endorsed, that you do need, if the Advocate General is saying the same thing, to look at the Advocate General's opinion. And in that respect, can I direct you to the passage that starts at 713 under the heading, I would hope this is going to be helpful, interpretation of the phrase, vehicle for which the insurance obligation has not been satisfied. Well, there's our problem in a nutshell.
According to my note, most of AG 26 and AG 32 is specifically endorsed
That's right.
by the court. So, but I don't think any other section of this passage is specifically endorsed by the court, is it?
Yes, but AG 32 is the culmination of the analysis that's gone before.
I understand that.
And what you have, and it's evident my Lord has already very carefully read this section, is an examination of the purpose of the guarantee functions set against the purpose of Article 3 of the Directive. That's what you get up to AG 29. And then a very careful analysis of the Travo at 30 and 31. I won't repeat the Travo because I've taken you through it. But what the Advocate General says at 31 is he draws two sets of conclusions from that significant shift between the wording of the proposal and the final wording. First, it appears that in the mind of the legislature, a vehicle in respect of which the insurance obligations has not been satisfied was equivalent to an uninsured vehicle, which is confirmed, moreover, by the wording of the 5th paragraph of Article 1.4 of the Directive. And you have my point that it's confirmed by a great deal more in the content of the codified directive. Next, it's clear that in the final version of the directive, the EU legislature knowingly set boundaries to the circumstances calling for the payment of compensation by the body which was set up, inasmuch as it only expressed reference, other than to unidentified vehicles, was to vehicles for which the insurance obligation provided for in paragraph 1 has not been satisfied. That is to say, vehicles for which an insurance policy has not been taken out. The measure adopted in 1983 clearly shows that the legislature did not itself see Article 3 as a general clause requiring the member state to set up a guarantee mechanism. So it's all about, on the Advocate General's analysis, vehicles for which an insurance policy has not been taken out, not avoiding policies. It's worth noting that the legislature did not confine itself to providing that the body to be set up should pay compensation in the event of damage caused by vehicles for which the insurance obligation was not satisfied in general, but was minded to make it clear that this was to be the case only in relation to damages caused by vehicles for which the insurance obligation provided for by paragraph 1.
Slightly confusing language, that isn't it? It's repeated in the body of the judgment, but did not confine itself.
Yes.
Is odd because they're really saying the opposite. He's really
Yes.
saying the opposite.
I agree with you. It's another time.
It's a much narrower version of
Yeah.
what it might
I
be.
mean, one can't beat about the bush. Time and again, you get these types of linguistic problems with interpreting CJEU judgments and opinions. There's always something going both ways, but the substance of what's been said is pretty clear in my submission. It's that what was intended was two narrow categories of a circumstance, and that the long phrase meant a vehicle for which an insurance policy has not been taken out. Now, the Advocate General then explained all of this at 33 by reference to a rationalisation of the Travo which was that it was only in
But that
these...
phrase, that phrase is difficult too, isn't it? Because in normal English, you've got two different possibilities. One is the example we used earlier, which is where the insurer avoids successfully by whatever means before the incident, where there was a policy taken out, it's just been avoided before the incident. And on the other hand, what we've got now, which is where a policy has been taken out and has been avoided retrospectively.
Yes, but there's literally...
And if you were writing, I don't mean this, again, I don't mean this pejoratively, but if you were trying to write this in English, you wouldn't write anything like these paragraphs.
I think that's probably true of the entire directive.
Well, that may be right.
I mean, and it's one of the reasons, let's not, again, beat around the bush, one of the reasons why this directive has produced quite as much work for Mr. Moser as it has over the years, is some of the width or ambiguity in the language.
It's satisfied that social benefit, but apart from that, it's not.
Far more than the social benefit of my submission, but it has, yeah. I mean, it's a heavily litigated part of the CJEU, the EU's legislative canon, and that's generally a pointer to some problems in the clarity of the provisions. And that invariably reflects the fact that it's a contentious area in which legislative compromises are reached, and the language isn't always entirely clear where that's the case. So I can't hide from that. What you have at 33 then is a rationalisation of this distinction by the Advocate General. It's his own inference. There's no foundation for that in any of the materials that I can see. And then you see at 34, he says the situation in which the person responsible for the damage did take out an insurance policy, but with an insolvent insurer, is quite different. Essentially, the case before the referring court highlights the fundamental difference between, on the one hand, the general rules governing insurance against civil liability in respect of the use of motor vehicles as progressively harmonised, and on the other hand, the rules under under which civil liability insurance is guaranteed, which, to my mind, have largely yet to be developed. And then what I'd also point you to is his final remarks at page 719. Taken as a whole, the foregoing analysis shows there's nothing explicit in the wording of the relevant legislation to support the assertion that the compensatory body has an obligation to pay compensation where the insurer or relevant person is insolvent. Whilst it's true that the analysis of the legislative text and their development over time reveals a constant concern to protect victims, that's undoubtedly true, it also makes apparent the fact that that concern was duly offset against the financial burden represented by the payment of compensation by a body such as that provided for in now Article 10.1, with the result that even today the body is required to pay compensation in only two specific situations, and the member states are still able to limit such payments. Lastly, I should like to emphasise the important difference that exists, in my view, between a vehicle in respect of which the insurance obligation described has not been satisfied, and a vehicle insured with an insolvent insurer. After all, the vehicle for which the insurance obligation has not been satisfied is an uninsured vehicle. The vehicle which was insured has satisfied the duties, etc. The risk cover is genuine, but the compensation is delayed by the financial situation of the insurer. So there we have Sonka, and true enough, at this stage, it's only authority for the proposition that Article 3 and Article 10 don't reach into the position of insolvency. That's as far as Sonka goes. And that's the state of the law when one comes to the two relevant domestic cases of Delaney and Roadpiece. And in our submission, that's the basis for the distinction of Sonka, and it's understandable enough at the time. But Fidelidade makes it plain that this reading of Article 10 extends beyond insolvency context, and it extends into a situation of putative avoidance. And it's really the taking up and running with the Sonka baton in Fidelidade that is a significant development, which isn't addressed for a variety of reasons in the domestic cases. And for instance, if you look at the cases cited in Lewis and Tyndale, you will look in vain for Fidelidade even in the cases cited in the Skeleton arguments. Why is that? Well, because Lewis and Tyndale wasn't a case involving avoidance of a policy, as we heard from a learned friend's helpful interjection earlier on this morning. So, I'll make a start on Fidelidade unless you've had enough from me.
I think make a start, please. Thank you.
It's in tab 30 of the authorities bundle. And it's the Article 10 problem cropping up in the very context of policy avoidance. Advocate General Mengozzi was again the appointed Advocate General for the case, but the court decided to dispense without an Advocate General's opinion. You see that at H12 on page 755.
Does it matter? But it's a horizontal case, isn't it?
Yes, it is. Absolutely. And that's a point.
On this occasion, I think I've got it right. It is a horizontal case.
Well, it's a case. It's a case in which the relevant dispute was really a Portuguese mar-leasing dispute about whether or not Portuguese provisions should be interpreted to permit the insurer to avoid liability. I think that's how the dispute arose. Let me show you why I say that's the case. The problem lay, you can see this from paragraph 11, in the fact that the Portuguese law, page 757, Article 14 of the Portuguese law, enabled an insurer to invoke national provisions that led to the nullity or invalidity of the insurance contract as against the victim. And that was effectively an incorporation by reference of the provisions of the Portuguese Commercial Code and its provisions dealing with insurance that provided for nullity, effectively, of the contract of insurance, void ab initio, on grounds of inaccuracies or omissions. So if there was a breach of what we would call the aberrima fidei obligation, that led to the nullity of the contract of insurance under the Portuguese Commercial Code. And there appeared to be an ambiguity as to whether or not those provisions, as a matter of Portuguese law, could be used to avoid a claim by the victim against the insurer. And you see that at paragraph 13 and following. There was a road accident resulting in the death of both drivers. The case Suisse de Compensation brought legal proceedings against the FGA. That's the Portuguese equivalent of the MIB. And Miss Cristelo Pinto Moreiro seeking reimbursement of the sum paid to the family members of the insured. So I think this is a situation where effectively the cross-border provisions are being used to invoke an obligation to pay back someone who's already paid out the claim.
And the case Suisse was the insurer of the motorcycle rider. I get that from the fact it says it had paid €285,000 to family members of its insurer.
You're quite right. You're quite right. But the critical fact is in 15, the defendants in those proceedings argued the legal proceedings could not be brought against them. So that's the MIB, if you like, saying you can't bring claims against me based on the argument that at the time of the accident, a valid insurance contract was in place, concluding with the company now known as Fidelidade Compañía de Seguros, the insurer, which covered civil liability in respect to the motor vehicle concerned. So the MIB was saying, well, the person who caused the accident was insured by Fidelidad Compañía de Seguros. Called on to join the proceedings, that's the insurer, the company maintained that the contract for motor vehicle insurance against civil liability was not valid on the grounds that the policyholder concerned had made a false statement on the date that the contract was concluded, claiming to be both the owner of the vehicle and its usual driver. So that's pretty much identical to the facts of our case. Exactly the same type of misrep. The court hearing the case at first instance ruled that the insurance contract was not valid and that the invalidity could be invoked against the victims. Then there's an appeal, which ruled that the contract was not valid, but such invalidity could not be invoked against the victims. The insurer appealed against that on a point of law to the Court of Appeal in Porto, against the Porto Court of Appeal's decision to the Supreme Court in Portugal, claiming the insurance contract was null and void, and such nullity could be invoked against both the victim, Mr. Seaman, and the victim's insurer. And that was what triggered the request for reference. You see it 18 in the last 3 lines. Pursuant to Article 14, such nullity may, according to that line of Portuguese case law, be invoked against the victim. That's the argument being made. That approach takes account of the fact that the victim will always be protected via the MIB. So the argument that they were making, the insurer was making, is don't worry about nullity, because if we win with our nullity argument, it's the MIB Portugal that will have to pay. And so they were invoking what they said was the wide width of Article 10.1 in support of their argument for nullity being permissible. And it's that argument that then led to the questions referred at paragraph 20, which referred to what are now, in effect, Articles 3, 10 and 13, and capture that question in a nutshell. That probably is a convenient point to stop if that's convenient to the court.
Yes, thank you. What is the timetable in general terms from here on?
Well, I'm sad to confess I haven't agreed anything explicit in advance with Mr. Moser. On my note of the 44 pages I had, I'm up to 32. So I'm doing reasonably well. I'm obviously having to open the provisions and the authorities.
Yes.
And now that round 2 is no longer on the decks, I'm hopeful we're going to finish in the day and a half the case has been allocated. I'll be as quick as I can.
Does that seem realistic, Mr. Moser?
Yes.
Well, if you're as economical as that, clearly it will be. Thank you very much.
Court rise.
2 o'clock, please.
Tom, where do your authorities divide? Because we've printed them out slightly